Good day, everyone. My name is Katiraja Raja. I am from Group 2. Today, I am my teammates present about the law system, litigation process, and court system in Malaysia. Let's start with the introduction. By understanding the legal framework in Malaysia is very crucial for professional involved in GIS. Mainly, it ensures a compliance with the law and regulation related to the data collection and privacy, which is helps protect individual rights and avoid legal issues. Then, legal knowledge is very crucial for creating a clear contracts and agreement, such as data sharing and service level agreement, reducing a risk of disputes. Moreover, by understanding the legal system, it minimizing legal risk and being prepared for potential litigation, which is very important for risk management. Moreover, not only that, it also ensures the ethical use of geospatial data, respecting privacy and environmental regulation.
Overview of Malaysian legal system. There are three types of the Malaysian legal system. First is civil law, second is martial law, and third is Sharia law. For the civil law, based on the common law tradition similar to that of the United Kingdom, it forms the backbone of the country's legal framework. It also offers related to the common crimes and individual or entity protection from crime. For the martial law, it often related to the army and under the act just related by army law. The reason why we apply martial law because the war and invasion, civil disorder, and also natural disaster. Martial law represents a significant departure from the normal governments and is typically viewed as a measure of the last resort due to its profound impact on the civil rights and societal order. Lastly is Sharia law. It offers or act related to the Muslim in terms of the marriage, divorce, custodial maintenance of the children, matrimonial or limonial law of the succession, and etc. Sharia courts operate the parallel to the civil courts with a hierarchical structure of the Sharia appeal courts, Sharia high courts, and Sharia subordinate courts.
Next, we're going to see the court of system in Malaysia, which is they have six compartment, which is in this hierarchy in this slide, which is federal court from the first court of appeal, high court of Malaya, high court of Sabah Sarawak, and this is in the superior court, which is they have a special court, while subordinate court will be included with session court, magistrate court. The court system in Malaysia, we're going to one by one from the first hierarchy, which is federal court, which is the highest court in Malaysia, which here from the appeal from the court of appeal with granted leave, criminal appeal handle appeal from court of appeal or for cases which is heard by the high court, and the supervisionary court role reviews decision and supervise lower courts. While the court of appeal, it it has a civil it have a civil court which is handled from the high court excluding consent judgment or orders, while the this is can be come from criminal appeal, which here appeal from the high court criminal decision, and which is they have a final jurisdiction which for cases originating in subordinate court. Next, we're going to the third layer, which is the high court. They have supervisionary jurisdiction over subordinate court, civil jurisdiction unlimited for claim over 1 million except specific cases. This includes matrimonial, bankruptcy, company winding up, guardianship, probate, wills, injunction, contracts, and legitimacy. By the criminal jurisdiction, unlimited except for Islamic law, handles capital punishment cases, which in within review by application are processed here. Next, in High Court of Sabah Sarawak, they have supervisionary and revisionary of jurisdiction similar to the High Court of Malaya, which they have unlimited jurisdiction over civil claim and special cases, which they also include by serious criminal cases, including those punishable by death. This is the last layer, which is the subordinate court, which they have session court. By this court, they have civil cases up to 1 million, unlimited for motor vehicle accident, landlord tenant disputes, distress, as per Subordinate Court Act 1948. And lastly is magistrate court, which is the first class magistrate legally qualified by broader power, second class magistrate lesser power, not necessarily legally qualified, jurisdiction minor civil and criminal cases. And last but not least is the other court, which is the other smaller court, which is include by Penghulu's court, native court, court of children, special court, and not and lastly is Sharia court that limited to Muslim.
Next is the pre-trial procedures, uh, which contains by filing a complaint where we must initiate a lawsuit by submitting a statement of claim to the courts, and then the service of process, where delivering legal documents to the defendant. Thirdly is response, where defendant files a statement of defense. Next is discovery, where exchange of relevant information and evidence between parties happens. And then we have, lastly, is the pre-trial conference, where meetings were held to discuss the case and explore settlements of options.
Okay, moving on to the litigation process, which is trial. So the first one, we got opening statements. So the purpose of the opening statements, it is provide each party with the opportunity to outline their case to the court. This is not evidence, but a roadmap of what each side intends to prove during the trial. The second one is presentation of evidence. Witness testimonies, documents, and other evidence are presented. Cross-examinations are conducted to the challenge, credibility, reliability, and evidence. The third one is closing arguments. Both parties summarize their cases, highlighting key evidence and legal points. Next is judgment. The judge delivers a decision based on the evidence and arguments presented. Last but not least is appeal. If dissatisfied with the judgment, parties may appeal to a higher court.
First, data privacy and protection. Many jurisdictions have laws protecting personal data, such as General Data Protection Regulation (GDPR) in Europe and CCPA, which is California Consumer Privacy Act. GIS professionals must ensure that geospatial data containing personal information, such as locations linked to individuals, handled in compliance with these regulations. Second, intellectual property right. It is divided by two, which are copyright and licensing agreements. Let's talk about copyright first. Geospatial data may be protected by copyright, and GIS professionals need to respect the intellectual property rights of data owners. Second, licensing agreements. Understanding and adhering to the terms of data licensing agreement is crucial. This includes recognizing the limitations on how data can be used and shared. Third, data accuracy and liability. There are often legal requirements or industry standards regarding the accuracy of geospatial data. Failure to meet these standards can lead to liability issues. Also, GIS professionals may be held liable for damages resulting from errors or inaccuracies in geospatial data. These highlight the importance of quality control and accurate data representation. Lastly, confidentiality and security. Certain geospatial data may be sensitive, like military and infrastructure, requiring strict confidentiality and security measures to prevent unauthorized access and misuse. Legal ramifications of data breaches can be severe, necessitating robust cybersecurity measures to protect geospatial data. There are 4 things to ensure GIS activities comply with legal standards to avoid litigation. First, regulatory compliance. Second, standards and best practices. Third, documentation and auditing. And last, legal advice and training.
In conclusion, knowing the Malaysian legal system is essential for GIS professionals. It includes understanding civil, martial, and Sharia law, the court structure, and how legal cases are handled. This knowledge helps ensure that GIS activities follow the law, protect people's rights, and avoid legal issues. It also helps in making clear contracts and agreements to prevent disputes. By understanding the legal requirements, GIS professionals can handle data responsibly and ethically, following privacy and environmental rules. This understanding is crucial for managing risks and successfully operating within the law.